From the main list, item number 1.
Yes.
My lord, I am appearing for petitioner, your lordship. As per your lordship last direction, my lord, on 7/9/2020.
Just give us a minute, please.
My lord, as per last
Give us a
order,
minute, please.
my lord.
Yes, yes, Mr. Goel.
My lord, as per your lordship last direction, my lord, state has taken time to comply with the order passed by learned NGT, your lordship. And my lord, as per my instruction, my lord, still my lord, the coke plants are, my lord,
Very good.
running, your lordship.
Yes, what is the position, Mr. Advocate?
Yes, Your Lordship. Action plan in terms of the NGT order has been prepared, my lord, and time has been given to MSPCB to close down those who are not complying within a period of 1 month, my lord. That has been done recently only, my lord. That's why Mr. Goel is not having that information. It was done recently only. So this action plan is ready, and one more development has taken place in the...
When did the NGT pass orders?
This was passed on 7th of July, my lord.
Yes. Can we have the NGT order, please?
Lordship, it is part of the affidavit in opposition at page 8 July, my lord. That is at page 18 of the counter affidavit. And in the meantime, one of the party has gone to Supreme Court. Honorable Supreme Court has issued notice both on SLP and interim stay. Matter is listed on 12th of this month, my lord.
Where is the operative part of the...
Your lordship will find at the...
Page 65, my lord.
65.
Paragraph 49.
July.
8 July, your lord.
So
8 November.
Taken us to November.
8 November.
So we therefore direct the state of Meghalaya to take appropriate action
Yes, sir.
to frame an action plan regarding the offending so-and-so. Such action plan as implementation shall be carried out within a period of 4 months.
Yes, sir.
So you've not done that within 4 months.
Yes, Your Lordship. There is a delay of 1 month, but before that, my lord, on 7th November, one of the party has gone to Honorable Supreme
That's
Court.
neither here nor there. There is no order of the Supreme Court interdicting the order.
Your Lordship, yes, Your Lordship, there was some delay on account of some confusion because then I saw the order. I said that there is no order interdicting the order of NGT. Only the Honorable Supreme Court has said that notice on stay, and that matter is listed on 12th.
That's all right. The matter was adjourned on September 7, 2022 on the representation of the state that pursuant to orders passed by the National Green Tribunal, coke plants operating without meeting the required siting norms, SITING, were required to be shut down. Full stop. The order also recorded that the State Pollution Control Board had issued new siting norms which had also been challenged by several parties in proceedings before this court. Full stop. Learned Advocate General submits that an action plan in terms of the relevant NGT order has been framed on
23rd December, my lord. Yesterday.
23rd December is...
Sir. November, sorry, I'm sorry, 23rd November, my lord.
Has been framed on November 23, 2022, and such plan is expected to be implemented within what time?
1 month, my lord.
Within a month from the date of its notification. Full stop. Paragraph. It must be observed that the order passed by the National NGT on July 8, 2022 called upon the states to take appropriate action to frame an action plan regarding the offending coke oven units established prior to December 23, 2020 to make them compliant with the siting norms laid down in the notification dated December 23, 2020. Full stop. The said order of the NGT was clear in indicating that open court capital such action plan AP capital and its implementation shall be carried out within a period of 4 months. Full stop, close quote. Paragraph clearly, the state is in breach as the action plan was prepared beyond the period of 4 months and its implementation is expected to be completed, if at all, by December 22, 2022, without seeking any extension of time or leave from the NGT. Full stop. Paragraph. The further direction contained in the NGT order of July 8, 2022 requires the state to recover environmental compensation, open court, according to procedure established by law, full stop, close quote. It is hoped that the state takes appropriate steps in such regard. Full stop. The State Pollution Control Board should also maintain a strict vigil to ensure that the environmental norms are not violated and, if violated, immediate appropriate action is taken. Full stop. Paragraph. In a matter pertaining to, in the suo motu proceedings instituted by this court pertaining to illegal coal mining in the state and the failure by the state to comply with the directions issued by the NGT and the Supreme Court pertaining to coal mining in the state, it was noticed that in addition to the quantum of previously illegally mined coal that had been seized, a large amount of coal was available, full stop, since the additional amount of coal has obviously been mined illegally, as no license in such regard has yet been issued in the state, the state has been called upon to seize, has been called upon to take appropriate steps for disposal of both the previously illegally mined coal and the illegally mined coal subsequent to 2016 or thereabouts. Full stop. In such connection, the order passed on the matter on December 7, 2022, noticed that there were several coke oven plants and ferroalloy plants in operation without the source of coal obtained by such plants being indicated or otherwise available. Full stop. The state has been called upon to ascertain the source of coal used by such coke oven plants and ferroalloy plants, so that the rampant illegal mining, coal mining that continues in the state and continues to be reported in the press is arrested. Full stop. Paragraph. It needs further mention that there is no prohibition on the mining of coal as long as it is done in accordance with law. Full stop. However, it is the clear stand of the state that no license for mining coal has yet been issued, though applications in such regard have been forwarded to the relevant ministry of the Union, and such applications are in the process of being vetted. Full stop. Paragraph. Let this matter appear 6 weeks hence. Before that, Learned Advocate General submits that a special leave petition has been carried to the Supreme Court from the NGT order of July 18, 2022. Full stop. Notice has been issued on the prayer for stay of the operation of the order made in the made before the Supreme Court. Full stop. The matter is due to appear on December 12. Full stop. However, there does not appear to be any stay in opposition at the moment. Full stop.
Your Lordship, this is civil appeal. This is civil appeal.
Civil appeal.
Civil appeal.
Or not specially petition, civil appeal. So there's a direct from the NGT. Yes. Let the matter appear 6 weeks hence, will appear last.
Okay.
DPO.
From supplementary list, item number 1.
My Lord, pursuant to Lordship order, the petitioner has filed a representation bringing on record the factum of custom before the District Council, ma'am. It is still pending there. So may I pray, madam, it be taken up after vacation, ma'am.
As directed by this court, we have taken the exercise. The process is on. Lordship
When
hearings
should we keep the matter?
In the
Tell us when should we keep the matter?
after vacation.
after
Very
vacation.
well. At the request of the parties, let the matter appear a week after the vacation.
Much.
Any other matter?
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
My lord,
There's some announcements made when the minister was in Guwahati about 50,000 crores being earmarked for Assam,
Matter Northeast probably.
9,000 crores for Meghalaya, a separate 6,400 crores for a bypass. Are they,
We have not received any official communication, my lord. It is only in the news, my lord. But if you can wait for some time, see if any communication is made with regard to those announcements. But otherwise,
why don't you try and find out that these were reported in the press?
My lord.
And these were apparently announced by the minister, by the union minister.
My lord.
So what is the actual position?
My lord, we can.
I just want to bring, my lord,
Yes,
to the notice
yes,
of this
yes.
honorable court, that,
No, we are just seeing the larger picture, the smaller picture we'll see, yes.
lordship, that they placed a big hoarding there in the Barrick Point and the Edman also, my lord, that claiming that the 2.2 kilometers of road is being constructed every day in parts of rural areas, my lord.
Yes.
That can be done, my lord. Why not this stretch of road falls in the rural area only, my lord? It's a big hoarding, my lord. Can be seen in the Barrick Point and Edmonds also, my lord.
My lord. That is, my lord, union, my lord, this. We are at the mercy of union, my lord.
There's something which go up on hoarding, some things which are done on the ground. And there's a huge difference between the two.
The state government order. State government order.
Let us say the hoarding is not to scale.
Lordship.
That knows of other parts of India.
It appears that a recent announcement has been made by the Union Minister for Surface Transport in Guwahati regarding augmentation of funds for construction of roads in the northeastern states. Full stop. Some announcements have also been made regarding infusion of funds for Meghalaya roads, including a bypass for Shillong, including a western bypass for Shillong. Full stop. Paragraph, however, it is submitted by the state should make every attempt to ascertain the position from the union, from the relevant ministry, since the announcement was made by the union minister, no less, in course of a visit to the northeast. Full stop. Let the matter appear a week after the vacation.
I'll apply, my lord.
Yes, Mr. Mudika, get some funds for us.
I'll
Get some funds for us.
write to them.
Item number 2.
Lordship, wait please, your lordship. Lordship, in this matter, the last order, your lordship has taken note of the fact that
How has the trial progressed?
My lord, as of now, 28 witnesses have been examined, my lord. Most of the protected witnesses have been examined, except one who is in custody in connection with another case in Kolkata, my lord. We'll
How
postpone.
long has he been in custody now?
it's been almost, my lord, 4 years.
4 years.
8 months.
And
4 years, 8 months.
what are the charges?
Lordship, the charges are under
UAPA,
UAPA and the other general sections of IPC, my lord.
other general section?
sections of IPC.
Now, what happened? Were there any deaths?
No deaths, my lord, no deaths.
Kidnapping for ransom.
My lord, the primary
For
allegation.
ransom. How much?
Amount was? 1 crore was asked. This was a construction company which was carrying out railway work in Manipur, my lord. And one of the employee of that company was kidnapped for, and the demand was for a ransom of 1 crore rupees, my lord. 25 lakh.
Was this the matter where Mr. Chakraborty moved forward for washing?
My lord.
This is the same matter?
Same matter, my lord.
Not same.
One of the
with
accused.
respect of the other accused, my
Other
lord.
accused, my lord.
This is the principal accused.
No, my lord, he is only a receiver of the ransom. He is nowhere connected. Not the allegation is
Receiver
of
of
the
the
receiver.
ransom, but after triangulation, it was found that he accompanied the wife of the principal accused. They traveled together.
No, my lord.
Yes, yes.
The wife was arrested separately, my lord, of course, subsequently released on bail.
Why don't you think of some strict conditions? Because 4 years is a lot of time. And at the end of the day, if he is released or if he is acquitted, then how are we going to return the 4 years to him?
We are
Think
willing
of
to, my
some
lord,
stringent conditions, but it can't go on endlessly.
My lord, originally there were about 170, 180 witnesses, my lord, in the list. We are pruning the list, my lord. We propose to examine another 30 witnesses, something, my lord, now.
Only
178
28 done,
28
another 30,
My lord.
and 28 done over the last 6 months or so.
My lord.
Another 30 will take us another 6 months.
there are about 178 witnesses, my lord.
There are checks and balances now. We have gadgets where you could monitor his movements, but
We are willing to abide by any condition, my lord, any condition.
this can't go on endlessly.
May I pray for some time, my lord? I'll have instruction from the department, my lord. But because they are the people from Manipur, my lord. Of their
People
disappearance,
from Manipur means no bail.
my lord, the possibility of disappearance is very high, my lord.
But you have tracking devices.
But the
There are very sophisticated tracking devices.
the crossover to the neighboring countries, my lord, then it becomes an international issue, my lord. Then it becomes very difficult.
My lord, so much so, my lord, we are willing to report to the officer in charge every week, for whatever period, my lord, may so direct.
The taller the promises that you make, the more suspicious the court gets.
My lord, the only problem on the last occasion, my lord, was of the view that 5 years is too long a period. And, my lord, the respondent, my lord, the learned DSG, my lord, had submitted, he only expressed his reservation so far as the examination of protected witnesses are concerned. Now the protected witnesses are already over, my lord. I don't see any obstruction so far as the release on bail is concerned.
This matter has come up from time to time, and adjourned since the trial is progressing in right earnest. Paragraph. However, the petitioner has now been in custody for nearly 5 years, and it is unlikely that the trial would be completed within the next year. Full stop. There is no doubt that serious charges have been brought against the petitioner, including under the UAPA, including under the Unlawful Activities (Bracket Prevention (Bracket Close) Act 1967, but it is not acceptable that the petitioner be detained for such a long period of time, even before he is convicted. Full stop. At any rate, there is always a possibility of the petitioner being acquitted, and no amount of compensation can return the years that the petitioner has lost. while in detention. Full stop. Paragraph. The union submits that the number of witnesses has been pruned down and 28 of about 70 witnesses have already been examined, including most of the protected witnesses. Full stop. The union assesses that the rest of the witnesses should be examined within the next 6 months. Full stop. Paragraph. The petitioner claims that the initial ground for resisting the prayer for bail was that there were protected witnesses who would be vulnerable if the petitioner was released on bail. Full stop. The petitioner says that it is now the union's case that the petitioner may slip away into a neighboring country. Full stop. Paragraph. The matter will appear 4 months hence. Unless the evidence is completed by then, the petitioner is likely to be enlarged on bail, subject to any stringent conditions that the union may suggest. Full stop. It must be recorded that there are sophisticated and secure tracking devices now available that the union should look at. Union should look at. Full stop. Paragraph. Give the matter a date.
Lordship, in that regard.
You show this to the trial court. The representation over here is there will be 70 witnesses.
About 70.
You show it to the
They
trial
are saying that, my lord.
They can't make one submission here and another there.
Absolutely, my lord.
Please put it down. We've recorded it over and over again. Yes.
Item number 3.
My lord, in this appeal, I've taken the plea of jurisdiction, my lord.
Okay.
The other connected matter we heard first.
Let this matter appear after the lead matter is decided, post the matter immediately after the vacation.
Obliged.
Yes.
From the main list, item number 1.
My lord, in this matter, I was praying for some accommodation. Only for today, my lord. I was not feeling well yesterday. My lord.
No, not this matter. Yes. This is a review petition.
My lord.
Yes.
Only for a day, my lord.
No. Don't embarrass us, please. We've given you enough time. There's a connected matter which is pending because of this. Let's finish it. Yes.
Lordship, then I may be allowed, Lordship, because even the conducting counsel, Lordship, he has a health issue, Lordship.
Very well. Since the parties request an adjournment, let the matter appear immediately after the vacation.
Lordship, there is a item number connected, similar matter.
Sorry?
There is a similar matter.
It will
that is
appear on
item
the same
number
day.
4.
I'm deeply.
Item number 2.
My lord, this is one of the lead matter regarding this jurisdiction matter.
This is the lead matter.
It's the one.
Lordship, just giving a leave the court if the court can accommodate to the end of the board. This matter. The Advocate General is slightly preoccupied, Lordship. If it can come up in the end of the board.
When do you want it? Tell us. We are here.
Advocate General is here, Lordship, but just for accommodate for the end of the board.
Don't follow you, Mr. Khan.
End of the board, Your Lordship.
End of the board, very well, end of the board.
Item number 3.
Yes, Mr. Vijay.
Very please.
There's the other matter in which the issue is whether the trial court was vested with due authority to take up the trial. Initially, there appears to have been some anomaly, but it appears that in accordance with the 37 rules, which are now repealed, district courts took up the matter as additional delegates or whatever, delegates of the executive authority, which
Yes, ADCs, the ADCs one.
ADCs, yes. Commissioners, deputy commissioners, additional deputy commissioners.
They were adjectives.
So we are inclined to accept that everything has been done in accordance with law. If you take the point of jurisdiction, that is the lead matter, which is the last on board, for which you have to wait. And there again we are telling you we are inclined. Otherwise it would lead to a lot of
Going back, remanding back, trial again.
and therefore we'll indicate that. And of course, on the factum valid line if necessary. So if you're not taking that line.
No, I'm not taking that point. Let's go to the facts part.
Facts and merits.
Yes. But only thing, there may be a passing reference to the, because I have not understood one thing, my lord. As per the rules, it was the spirit of the CRPC. Now the spirit of the CRPC has not been defined anywhere. So it becomes the discretion of the court to decide what is the spirit or ask to interpret what is the spirit of the CRPC.
Just to give you an example.
Yes, my lord.
For instance, the basic structure doctrine.
Right, my lord.
There is no inclusive definition of what forms the basic structure.
Right.
There is nothing inclusive.
Right, my lord, absolutely right.
In Keshavananda Bharati, something was indicated. If you come to Coelho,
yes,
where the schedule was discussed,
yes,
it was also said that there is something, though Coelho should have gone the other way.
Yes.
Should have gone the other way. But, so there is not, similarly, in arbitration, the law of evidence does not strictly apply.
The spirit applies.
The principles of evidence apply.
Yes.
So to the extent the Criminal Procedure Code carves out a fair procedure, affords an opportunity
to the accused,
to both the accused
and the
prosecution,
yes, my lord,
to put forth and deal with the case, and are afforded a fair opportunity to present their versions, a fair opportunity to look at the records, what we call fair procedure. And the principles that run through the Criminal Procedure Code or the provisions, even though you can't say that this is contrary to
the CRPC,
section so and so CRPC, or this is contrary to that, but if the procedure does not result in manifest miscarriage of justice, that
would be a fair procedure. My lord, only one thing what has been troubling me, my lord. I accept that the Session Judge was right. He had the authority. Let's, for argument's sake, we're accepting it. But the question here is whether the procedure which was adopted in accordance with the law at a stage where it was to be heard prior to the arguments, prior to the charge being framed, and within a day, the changeover to no commitment and the charge being framed without compliance of certain procedures of law. The certain procedures of law was non-supply of documents under 12(7), no commitment taken, and in neither case, the ADC, as my lord knows, under the 1898 Act, which was the procedure which was being adopted by the ADCs, there was this scope of a pre-trial committed proceedings before it went to the Court of Sessions. So it would be in that form which gave away in the 1974 Act. There is no such thing as a committal proceeding in 74 Act, only it will be committed. What is being committed, not the accused, but the case. Now, in this case, let me go to the merits of the case. The merits of the case is, the incident takes place on the 9th of February 2008. Now, when it took place on the 9th of February 2008, on the 10th morning, in front of a DC's office, the body was found. Now, PW4, who happens to be the brother of the deceased, while going to fetch water, sees the body of his brother lying there in front of a big tree under the DC's office. So he immediately informs the police. Inquest is started, post-mortem is being done, and ultimately, at 3 o'clock that day, that is on the 10th of February 2008, against unknown persons, an FIR was lodged. This FIR, which was launched on the 10th of February 2008, reached the court of the magistrate on the 26th of May 2008. When one person by the name, under the name style of PP, was arrested and produced in court. Now, the whole incident, as sought to be projected by the prosecution, speaks about the evidence of 2 witnesses. In all, 7 witnesses were examined. The 1 is alleged eyewitness, 2 is an alleged eyewitness, 3 is the PM doctor, 4 is the complainant, 5 is one of the eyewitnesses, 6 is one IO, 7 is the ultimate IO. So we have 7 witnesses in this category. Now what I've been trying to drive home to your lordship is, this 1 and 2 were examined on 9th of June 2008. Incident one I have to remember is 9th of February 2008. In the meantime, that gentleman who was arrested, who was taken into police custody and has said that I would show you the place, I am the person responsible for the death. He is discharged by the charge sheet on the 30th of August 2008. I am arrested in the form of arrest, anticipatory bail allowed, then arrested, then granted bail. Now, one of the most important things here is whether my lord will trust these 2 witnesses who cases, very interestingly, the statements were made after they were detained by the police. For a minute, my lord, if your lordship will please see section 163 on the CRPC. It was there. 163. No police officer or other persons in authority shall offer or make or cause to be offered for make any such inducement, threat or promise as is mentioned in section 24 of the Indian Justice Act. Now, like conspiracy, But like conspiracy, my lord is aware of, conspiracy is normally held in secrecy. Because you won't even conspire in front of 4 witnesses or something. Like here, my lord, your lordship has to see whether section 3 of the Evidence Act pertaining to relevancy of the act, evidence given by PW1 and PW2, that they gave the statement after being detained in custody. Both of them. Right, my lord? Now, my lord, when we see these witnesses,
They made statements under 164(4).
First, 161, then my lord, 164(4).
But 163 has no impact on 164(4).
Same day. Police got them and police was outside the courtroom. That is what PW2 has said. So but the inducement threat conception, your lordship can't point it out.
And who recorded the 164?
The magistrate, which was never brought to the court. It was never exhibited in court. Not required, public document maybe. But that was never brought to the court. And not even in the 313 examination.
No, if it was not part of the records, how could it be part of 313?
Conviction is based on 164 by the learned judge. The learned judge has based his conviction under 164.
And 164 is not there part of the evidence.
No. Well, I just start with one.
It was not forwarded to you with 207 papers.
Nothing was. I was just telling you what you at the beginning. No compliance of 207. No compliance. My lord, the manual. Well, I just tell you, lordship, the manual, which is now the Bible for IOs of Manipur, Meghalaya, is of Assam. Now, Assam, under Rule Regulation 196, my lord, the biggest flaw I find in this investigation is non-compliance of Regulation 196, which speaks about in heinous crimes like murder, there has to be a sketch map. Number one. Number two, my lord, your lordship is aware, when the learned judges take evidence, the demeanor of the witness is one of the priorities which has to be seen by them. No whisper. Thirdly, there were 6 persons according to PW1 at that place. Right, minute. Two of us, one who has died during course of trial. The next one relates to 4 persons. Out of 4, PW1, PW2, PW3, PW5, and PW, the other alleged eyewitness was never even examined. Now, PW5, who according to PW1 and 2 were at the place of occurrence when the incident takes place, doesn't speak. He says, I do not know anything about the incident. And he was not declared hostile. My lord, your lordship sees, my lord had asked a very pertinent question on the last day. What do you say about the evidence 1 and 2? Now, 1 and 2 are witnesses. Who? Well, just a nutshell, before I read the paper book, my lord. It's in a nutshell, I'll just tell your lordship. One has a beef, he's a seller of beef. 2 is a seller of pork. Both of them came to play carom. One, they came to play carom. While playing carom, my lord, they just came, they sat and they saw that these 2 persons, namely SKT, who has since died, started assaulting the deceased with a dao. PW1 speaks about after the first blows and all was given by PW, by the petitioner who has died, appellant who has died, then I took the dao from him and again assaulted that deceased. That is PW1. PW2 speaks about both of them attacking it at the same time. Now, my lord, the question here is, as my lord is aware of, when the basic ingredients subject to corrections by my lord is, when an offence is committed, my lord, we have to see first 4 things. The necessary criminal intent on the part of the accused. Now, my lord, in this case, if your lordship sees, first is the intention to commit an offence. The second part is preparation to commit that offence. The third part is attempt to commit that offence. The fourth part is the attempt succeeding and I commit the offence. In this case, what we have is, they come, 1 and 2 immediately come 6, and allegedly we too started assaulting the deceased. Nothing there which suggests even a fight, strong words being used, shouting being done, and then as a consequence this incident happens. So one of the question which is uppermost in my mind, subject to corrections by my lordship, whether these 2 witnesses can be trusted or not. But if we go by the evidence of these witnesses, my lord will appreciate that these witnesses who were there stayed up to 12:30 in the night when the door was opened according to the prosecution case. Then they went in a Maruti car to have dinner, keeping the body there. Then they, after having dinner, they come back to the place where the incident took place according to them. And thereafter, my lord, the other appellant in the other case, Kovind, he alleges takes the body on his chest and dumps it in front of the DC's office, and PW1 and PW2, they guard the entrance to allow them to go. Now, my lord, your lordship is aware of that whether your lordship will treat these witnesses, the 2 witnesses, as witnesses having seen the occurrence, or whether your lordship will take them to be deemed to be accomplices to the crime. Now these witnesses, my lord, PW1 and 2. My lord, if I may take the paper book, my lord, I'll just read out the evidence of theirs, my lord. Bound one. Yeah.
First, your main points, Mr. Mukherjee.
My lord, first my main point is, the incident did not take place
on 9th.
At the place sought to be projected by the prosecution.
Incident did not take place at place of occurrence.
Yes. Which, my lord, your lordship will get it at page, at page 19. Two is, my lord, the inquest report, which was done at 8 o'clock in the morning, did not find place with the FIR in the 154 form, which was lodged at 3 o'clock. Thirdly, my lord, the incident could not have happened at 5 o'clock in the evening. If we go by the evidence of the Dr. PW3, evidence of PW3, my lord, the doctor. the evidence of PW7, fourth, speaks about the FIR was lodged by the sister of the deceased, which resulted in the investigation, not by the brother of the deceased, PW4. That's the investigation.
Repeat this again.
Well, the investigation which was started, if we go by PW4 statement and PW6 statement, it was on the basis of an FIR lodged by PW4. But PW7, who got the investigation in its hand on the 27th of March 2008, he speaks about investigating the FIR which was lodged by the sister of the deceased, which never saw the light of the day.
Yes.
Thereafter, my lord, your lordship sees that PW7 speaks about he arresting 4 persons. Arresting 4 persons, of which, my lord, 1 was acquitted, 1 died during course of trial, 1 was acquitted under section 201, convicted under 302, while the other was convicted under 2 and 1. Now, the best part is the IO could not identify them. The person who arrested them could not identify them in court, or was not even asked to identify them in court. Now, my lord, please let us start with the charge, please, my lord. Page 19 of the paper book, my lord. Well, would it be better, my lord, subject to corrections, if I make a short notes of argument with the written notes? Oh, here your lordship will do it. Yes. Well, please come to page 19 now. One line. One line more. One line. First, that all the 4 of you, on or about the 10th day of February 28, have murdered Sri so-and-so, son of so-and-so, and thereby committed an offence punishable as against 302. Well, do we have the compliance of, even though, my lord, I don't want to go, as my lord Justice Dingo had told me on the last occasion, not the correct, but we can't read the CRPC, but the principle is, but the spirit would be, no place of occurrence, where the incident took place, which forms a part of section 212 of the CRPC. No time, because my admitted position is, the dead body was detected, I'm using the word detected, on the 10th at 8 o'clock in the morning by PW4. If it was detected at 8 o'clock, where he was wrapped in a plastic jacket and in front of the DC's office, that also place has not been stated in the charge. If we go by the charge, that the murder took place on the 10th of February. So, madam, what we have, a case where 4 persons are being sought to be made accused and sought to be charged under 302 simpliciter. When we come to the word simpliciter, it would mean individual acts of each of the persons. And there, even combing also comes into the play, even graceful comes into the play as one of the murderers. Because the charge was that you four of all. Then the next part is, my lord. Second charge, that you also, I have to speak about combing taking the body with him. No a question of being dropping it from the Maruti car. So when the charge is specific about the acts supposedly done by four of them, where the failure to prove the charge inures to the benefit of the appellate convict. Secondly, my lord, if your lordship now comes after the charge, so it was 302 by 201. 201 was by 34, and 302 was simpliciter. Now, my lord, if your lordship will now come, please.
That's the 164 which he said was not produced.
It will not produce, my lord. Not taking even note of it. The judgment conviction is on the basis of 164. My lord, please now comes to page 65. PW1.
The charge sheet says that all four of you,
yes, my lord,
on the
only the date is given. Place of occurrence is not there.
Time is also not there.
And even when the time is not there. Now, Malan, let's come to page 65. Has my lord got 65, my lord? Page 65. PW1. I know the incident case. The incident occurred on the 9th of February 2008. So first thing, charge different, evidence is coming on a different way. On that day, I was in my shop selling pork as I am a butcher. After closing shop around 4:45 p.m., I went to the shop of accused NC, which is situated at Law Museum and styled as Equal Pharmacy, and there were 6 persons in the shop playing cards, for which I had also gone there. So, my lord, the place of occurrence, if we come to look at it, according to PW1, is known as Equal Pharmacy. My lord, not a single scrap of paper showing that this was owned by NC. Neither one. Nothing. The investigating officer didn't even have the courtesy, because he knew about it on the 9th of June 2008, pertaining to the place of occurrence as per the evidence, as per the statements of PW1 and PW2. But when it came to filing the charge sheet was on the 30th of August 2008. For 2.5 months, he didn't even find out whether the place of occurrence has sought to be projected, on the basis of which I have been convicted for life, was the place which belonged to the appellate presently before your lordship. Not a single scrap of paper not a single witness to the witness who were at the proximity of the equal pharmacy who had been examined and found out that yes, this belonged to him. Then, my lord, while I was there in the shop, the accused one, Sri Tang, who was also in the shop, assaulted and stabbed Macau, the deceased, with a dao. So we have the person who died during the course of trial, starts the ball rolling by attacking the deceased with a dao. Seeing this, 4 of the people present in the shop, namely Ling, but Ling is PW5, John Mallet, he was not examined, Mole is PW2, and myself, that is PW1, tried to flee away from the shop, but we could not get. Coming came to the shop and opened the lock from outside. So, my lord, let us understand, except what they say is correct. For argument's sake, my lord, I am accepting what they say is correct. So, from 12:30 p.m. and 7 hours prior to that, when the incident takes place, they kept mum, according to them, we were locked from outside. Right? So, they were locked from outside. Now, my lord, thereafter, my lord, if your lordship sees, came and opened the lock from outside. And thereafter, we came to so-and-so for dinner, leaving the person who was stabbed in the shop. So, my lord, in that scenario, they all went, 6 of them went to have lunch, dinner with the present petitioner, and the deceased who has died, the accused, for dinner. Then they come back again. When they come back again, then Kuming takes the body and dumps it in front of them to be accomplices. Because they participated in the disappearance of the evidence. But it is admitted because they say we kept watch. And then Kuming took it with them and they followed him. Then by the Maruti car, he was dropped to his house. Now, Malad, 2 things have been troubling me, Malad. Malad, I must be very, very honest and candid about it, Malad. 2 things, Malad, which is troubling me is, first is admitted position, the deceased accused person first assaulted him, that is the deceased, with a dao. So the injuries which were caused by the first assault by the deceased, whether by that stretch of imagination, that gentleman who died could have been standing to take the other blows. But one thing in my little experience I have, one thing which has been troubling me, my lord, if we go by the statement of the PM doctor, then the injuries, my lord, whatever injuries were there, 7 found, but all were on the left side. If all was on the left side, how could it happen?
Left side meaning looking at it?
Everything is from the left side.
Left side meaning?
It's the brain, the legs, the arms, the foot, everything, the injuries were there. 7 in all.
One-sided injury.
Only one-sided injury. And it's an admitted position by both of them that SKT, who has since died being an accused person, he was the person who launched the first attack on the deceased. Now, my lord, 2 things has to be appreciated, my lord, subject to corrections by my lord. The first thing, my lord, your lordship has to understand, my lord, I was going through the almanac. While going through the almanac, I find that on the 9th of February 2008, the sunset was at 5:11 p.m. If that happens, my lord, as per the Alam Act, then the question is, what was the source of identification by which they could identify both of us, or four of us? Secondly, my lord, according to the prosecution case, it was a 3-story building. Sorry, my lord. According to the prosecution case, it was a 3-story building. The shops were open on the first floor and the second floor. And nobody came there prior to that or after the incident. Because it is nobody's case that was locked or not. That is a knowledge which only comes at 12:30 in the night by these two witnesses. But if you are making Coming an accused, knowing that there was an incident of murder, and then you cause disappearance of that murder, then only 1 and 1 will be attracted. If 2 and 1 is attracted, then knowledge that there was a scene, there was an incident, that was a death there, has to be attributed to Coming. Other than that, my lord, the question of closing the door would never have arisen. We don't have any evidence saying that Coming was there on the spot, because according to these two witnesses you see, they speak about opening of the door at 12:30 in the night. Nobody says that after we came back, the door was locked from outside. Right, brother? So then now, Malad, the question arises is, failure for specifying the place of occurrence and the possession, the control over the property where the alleged incident PW1 and 2 are saying, which does not find place in the charge which was framed against me, whether this judgment can be sustainable or not. But the PW1, as my lord has said, PW1 has specifically said, my lord, that when the lordship comes to the next page, my lord, page 66, at the time of assault, the deceased was first assaulted by accused so-and-so with the da, and then by the accused so-and-so who assaulted and stabbed the deceased with the same da. So, my lord, the question here is, one does it, then again the present appellant does it. Now, my lord, the injuries, some are at the vital piece of the body. So the question of splurging of blood, nothing is stated, nothing has been said. One of the necessity now becomes, as my lord may be aware of, there is a provision under the code which speaks about the code below has the authority under section 310 to go to the place of occurrence and see it for itself. The entire case, my lord, they have not been able to say where, or I was asked the circumstances that at this place you assaulted so-and-so. Now, the reason behind this is, my lord, no incident could have taken place at 5 o'clock in the evening on the 9th for the following reasons, my lord. One of the first is the ocular evidence does not tally with the medical evidence. Now, my lord may say, which would get preference? If this ocular evidence was clear, untainted, it would have got precedence over the of medical evidence. But the question here is, one of the Lordship has to appreciate, the question here, Atmo, in my mind is, that the PM report speaks about the body being fresh at 8:50 a.m. on the next day. When actually, if we apply the principle as guided by Modi, it will be that putrefaction would have started after rigor mortis had spread over. One of the basic principles of saying when the death has occurred, the time when the death has occurred is basically on the score of, as per Modi, the first thing the doctor has to do is to attest the rectal temperature to find out when the incident took place. So if we go by the statement of one, who according to me, my lord, was under threat by the police to say what they had to say, because we have in evidence that the police who arrested him on the 8th, then released him on the condition that he'll go and make a 164 statement before the magistrate, is PW1 and PW2. And PW5 was threatened with arrest, but he was not arrested. So we have eliminated two persons, PW4 who says, I do not know any incident, and my brother was a drug addict, he was caught by people, and my brother used to come, normally he would have returned home at nights. That's PW4. Now PW5 says, I do not know anything about the incident, even though his name transpires from PW1 and PW2.
Yes.
Thereafter, my lord, if your lordship will please comes to PW2.
Not, in one sense you're right. I'm not looking at it trying to imagine, as they say, making a mental picture of what, it's not clear.
It's not clear. I'm grateful to your lordship. And if it is not clear, at least it is blurred, but I get the benefit. One of the, your lordship will see two things here. One of the charge, 10, no place, accepted. When I'm convicted 330, they don't say anything when the incident takes place. How can I be convicted for the circumstances not put to me? Now, please see the 330 for a minute, brother. I go to the next. Please for a minute, brother. Please come, brother. Right, 1-2 judgment. Yes, 1-1, yes. Yes, well, please comes to 1-1, 1-1. Well, just see, I'm not reading it out, not any date, anything given when the incident took place, the circumstances against me. See the next page also, Manad. Not a single mention when the incident took place in the 330. So it will be presumed that there was no such circumstances of night which could be put to the accused to answer the question of circumstances against him.
The question is put. Under 313 is the obligation of the judge to inform the substance of the statement Okay.
I be convicted on the basis of this 338? March, 9th, first IO, 6. 27th of March, the IO, first IO 6, he was entrusted for investigation by the DSP. 27th of March,
in what circumstances can we call for a fresh trial?
Well, this is one of the main circumstances. And the charge, prejudice by the charge. Now, to be honest with your Lordship, my Lord, I think I deserve that.
Because if it's an order of remand and retrial,
yes,
then we have to be guarded.
Yes, without saying anything, my Lord. Just
we have to be guarded.
Your Lordship can't specifically say, so I take advantage there. You can't take it. Neither can your Lordship say anything in his favor also. Your Lordship has to be very guarded to say it.
Acquittal is very easy.
Yeah, no issues. But if, Well, your Lordship, please appreciate one thing. The last IO, or the second IO, if I may say so, but he specifically says, since 9th of June till 30th of August, he doesn't do anything. He only arrests 4 persons and statement of these 2 witnesses. Nothing more, nothing less. Now, must just try and appreciate. PW1 is a beef seller.
Is a beef
seller. PW2 is a pork seller. Where is his shop besides the alleged PO? I'm using the word alleged PO. Well, is it believable? For 5 months, 4 months, they never went to open the shop. Is it believable after the statements were made, he will not show the IO the place of occurrence? Because the charge which was framed was on the basis of the 207 papers given to the judge. At that, right? So then why should there not be a place of occurrence?
No, don't understand this.
So they have a business. So they have a business there. Now the incident, after the incident, can it be believed that they sat for 4 months before making the statement? They would not have opened the shop.
No, matter of conjecture.
No, look, I'm just trying to put a doubt in your mind, brother. The second part is, brother, from 9th, the IO is aware of the place of occurrence because of the statement he gets to know equal pharmacy. What has been done to ascertain it belongs to me? Any neighborhood persons of the alleged PO, when the first floor and the second floor shops were opened on that date. And the conduct of these 2 witnesses, because there was an open veranda, there was a window, they never tried to bring it to the notice of anybody else. And when you say outside it was locked, you have to first say that somebody went out and locked it. Because combing, according to them, came at 12:30. He was then not there, so he can't be charged under section 302 at that place. That is why, the whole thing has been created.
Let's go back to the evidence.
Yes, Madam. Now, please, now comes to. My lord, if the lordship just finish 67, my lord, the last part of the examination. After the incident, just a second. Sorry, my lord. My lord, Justice Dindo has got it, my lord. Page 67, my lord. After the incident part. Lordship sees the last paragraph of page 66.
I'm just trying to reconcile.
Sorry, man. My Lordship has appreciated what I've been saying.
And where is the 164?
No.
Or not on record?
Not on record.
Yes.
Now my Lordship just reached PW to say he's much better. When I went to give 164, look at what has fallen from your Lordships of they remand back, my lord.
We look at the entirety before.
There are only 7 witnesses. Well, only 1 and 2, nothing more. Nothing more. It's a question of believing. If what he doesn't believe, I'll get an acquittal. No question of can we trust it or not. Take it. Oh, you know, the one. Let's see what he said.
He does not give, PW2 does not give any date
Of the incident.
of the incident. He gives the time.
At 4
Does
o'clock.
not give any date, 4 o'clock.
4 o'clock. He says quarter to 5.
One gives the date.
And quarter to 5.
5 o'clock.
5 o'clock.
Quarter to 5.
Quarter to 5.
Quarter to 5.
And one of the people also listened here. In PW2 statement, it's a different story. Both attacked simultaneously.
Yes, that's.
I know, I'm just trying to tell you, Lordship.
But the thing is that PW2, who says he goes at 4, finds Ham. Ham is PW1.
Yes.
Already there.
Already there.
John was not examined.
John was not examined.
Ling is PW5.
Not declared hostile. He said, nothing, I do not know anything about the incident. And one of the Lordship goes. The principle of law laid down by Supreme Court on that. If not declared hostile, supports the defense, your acquittal. And one of the inducement, if I may say, in respect of 1 and 2, of the detention. Of being detained prior to the statements being made.
The statement is not on record.
161. That is what they say first. 161 first, then pressure.
164 is not there.
Not there. It is not.
So 161, whatever may have been there, ultimately is the deposition in court.
Yes, the evidence is this. I leave it to Lordship now.
We'll get back to you, but
Yes, sir.
Lordship.
how do you know the incident?
Lordship, my case, Your Lordship, hangs on this evidence of PW 1 and 2, Your Lordship. Lordship, so far the evidence of PW, the evidence of the PW 1 and 2 are direct, Your Lordship. They pointed out, Your Lordship, in their examination, Your Lordship, that it was the appellant who smashed with the dog to the deceased, Your Lordship. That was and this piece of evidence, Your Lordship, was remained unchecked during cross-examination, Your Lordship. So it remains, Your Lordship. This remains, Your Lordship. It has not been
Demolished.
demolished, Your Lordship, during cross-examination. So it remains, Your Lordship. This is the direct evidence, Your Lordship. Because, Your Lordship, my case, as I have submitted, Your Lordship, hangs stand on this, Your Lordship, on these two witnesses, Your Lordship.
You are co-accused.
Lordship, no, Your Lordship, not co-accused, Your Lordship.
You were detained.
And Lordship, maybe they are, but they were never succeeded. They only that power, Your Lordship, he has been arrested and discharged because of lack of evidence, Your Lordship.
We will come back to you. Yes, let's go on with the IO and
Yes. Well, please comes to 82.
Your points were, your first point was, incident did not take place at the place of occurrence. On what basis do you make that point?
First is, my lord, the place of occurrence has to be supported by either the documentary evidence showing that the place of occurrence belongs, well, it's their story, that I was the owner of that property, it was my shop, and I had gone there. That's PW 1 and 2. So the place of occurrence has to fit it with two things. One thing is, any act which would go to show, other than the statement of PW 1 and 2, that there was something there. Because, my lord, as your lordship knows, where, how. So where is where? It's not there in the charge, my lord. And my lord, I've learned it from your lordship one thing, my lord. Motive is only in respect of circumstantial evidence. When it comes to direct evidence, then motive doesn't play a part at all, or may play a small part. Here, my lord, please understand, as I was telling your lordship, intention, preparation, attempt succeeds. So, my lord, the first three is not there, it comes directly to 4. Nothing, my lord, as if these two were waiting, I was waiting for them to come as eyewitnesses before I could hit them with an axe. There won't be anything prior to it. Not even a shout, not even anything. Well, see the conduct of the witnesses also. Well, on the 26th of May, when that gentleman by the name of PP, well, I can't pronounce it, PP, was arrested, he was taken into police custody. And while he was sent back from police custody, the IO specifically spoke about that he was the mastermind of the killing. Another thing is very important here, but this is one thing I would like your lordship to appreciate. But this DW1, a lady and a husband who subsequently died during the course of trial, they were charge-sheeted witnesses on behalf of the prosecution. And their statement was that at 12:30 in the night on that date, I saw the deceased in my place. And if your lordship tallies that part with the doctor's evidence. Now, one thing has been troubling me, my lord, the IO's conduct. The conduct of the witnesses who are seeing something going wrong. You allow two persons to assault. Once, first, you don't take any stance to give away that just break up, don't do it, try to stop them from doing it. No act. Two witnesses, the evidence of these both witnesses, for the purpose of 207, I am acquitted. But I am acquitted for the purpose of 201. So the second one goes away with the evidence. So when it comes to now 12-2, you act evidence on the same evidence. Because you were necessary to the crime. You were giving guard to the body before it left the shop. Now, if your lordship please comes to VW6, the IO, first IO. No, I am, during the year 28, I was serving as attached officer of Joy PS. I am the IO of the case endorsed to me by the then officer in charge. VW 6, page 98.
Yes.
Has the lordship got it, my lord? Just seize it, my lord.
Yes.
Then when it comes to 7, PW 7, page 100, my lord. Is there any place like Flemington in your village?
This diagram.
See, in 104, I have also. Well, if they had listened to and produced these two witnesses, would there be a charge sheet at all? Forget about a conviction, my lord. And, my lord, the best part of this case is, my lord, the IO arrests them, he could not identify them.
What does he mean by the second IO?
Yes.
No prayer was made for recording the confession statement of the accused?
Well, 164(1). And my lord, if your lordship sees 6 at page 95, third line, fourth line, and the, see the fourth line, 98, sorry. Well, it says, in course of investigation, I visited the PO. Which is just in front of DC's office. And 7 says, I did not go to the PO.
Who died?
One Muko something.
No, Muko is the
person who died.
Muko is the victim.
Oh, SKT. With tongue. Yes. He's the main. He's the
everything. The one who first hit and then
allegedly hit again.
And what happened to the other one, that coming?
7 years for 2 and 1. Even though I was acquitted under 2 and 1, so that evidence against me doesn't lie. That I took them with the body, P3 body carried, PW2 has said, P3 carried the body and threw it in front of the DC's office.
Take some time to consider it.
Lordship.
Because it's between acquittal or remand. There cannot be conviction on this.
Lordship, yes.
The 313 is completely wrong.
Lordship, yes.
In a 313, you don't say, what about the deposition of PW5?
The incriminating material could have been. Could have been.
You have to make him understand the 313 is completely wrong.
That, Lordship, I would.
Can it be next week? Subject to corrections.
Lordship, yes. We can have next week.
Next week, 15th, 14th or 15th, if it suits your lordships. List.
15.
Pushes us
Then Monday?
pushes us very
Monday is holiday.
Monday is a holiday.
over here. Monday is a holiday over here.
Tuesday, 13th.
On 30th.
Let it be on 13th then, Lordship, yes.
I'm grateful.
Yes, madam.
Lordship, the conducting counsel, Mr. E.P. Goswami, due to some difficulties, he couldn't come today. So I pray that the master may come after vacation, Your Lordship.
At the further request of the appellant to appear after the vacation, full stop. The appellant may not seek any further accommodation. Yes.
Second call, item number 2.
Lordship, just for it will be. Anything? Yeah.
My lord, this matter, Lordship has heard us many occasions, my lord. We will only, from my side, I need to just summarize my argument, my lord, on this jurisdiction
Have you
issue.
provision to finish it today?
Yes, Lordship.
You'll summarize and then you'll.
Yes, Lordship. Because Lordship has on the last occasion pulling Bihari's judgment, so I'm squarely covered by the judgment, my lord. Pulling Bihari's judgment also.
That's the fallback judgment.
Yes, fallback.
That's
Other
the
arguments I have
fallback.
already advanced regarding 1937 rules, appointment of district and session judge, and all those issues. So far as jurisdictional issue is concerned, I have addressed those points. I will reiterate.
My first point of summarization would be, my lord, that since the 1937 rule is still in force, in view of the Supreme Court judgment, and 1950, led by 1960, my lord, ATC is the competent authority to try cases, session cases, that report. That is a one, my lord. In view of that, my lord, appointment.
Brother, will you read the judgment here? Just follow it. It's better you do it if necessary. So you conduct it. You conduct it. Yes.
My lord, in view of that, my lord, the conferment given to the session judge to try the cases, my lord, it is not in consonance with law. My lord, because the ATC has a jurisdiction to try cases. Another point, my lord, would be that the conferment given by governor to the district council officers, Lordship, I have annexed those lists of notification also. Governor has appointed, confer the power to try cases under Para 1 or Para 5, not to the court of district council, but to the officers of the district council. Those notification, it is there, compilation is there, my lord. Therefore, it is squarely within the spirit of that Para 1 or Para 5 of the 6th schedule. So governor has conferred. Once he has conferred to district council, unless he notify or withdraw that one, my lord, he cannot confer any power, my lord, to the session judge, because there would be a concurrent jurisdiction would be there. Confusion would be there, my lord. And that is not the intent of the, my lord, the 6th schedule arrangement, my lord, arrangement. So once governor has given power to the court officers of the district council, they have to try cases, provided both the parties are tribal, coming from the same district. And immediately it is here, both the parties are tribal. That is one point. Another point.
Shows that notification.
Madam.
126.
Yes, madam. Yes. In that compilation, Lordship, can you see page number 145 onwards? It is very clear. Notification itself is very clear. 145. After final compilation of X rules and notifications.
145.
164, I'm so sorry. 164. Madam, this is 1989 notification. If Lordship is with me, might just read out, madam. It says, madam, madam, that in exercise of powers conferred by Subpara 1, paragraph 1 or paragraph 5 of the 6th schedule to the Constitution of India, the Governor of Meghalaya is pleased to confer on Sri Sansaj Taka, LLP Judge, District Council Court, who is hereby appointed, my lord, this is very important under the 6th schedule, who is hereby appointed by the Governor as the officer for the purpose of aforesaid paragraph, the power to try, my lord, the offences punishable with death, transportation for trial of, my lord, offences punishable for death, transportation for life, or imprisonment for a term of not less than 5 years under the Indian Penal Law or under any other law for the time being, applicable to the Khasi Autonomous District. So it says he has appointed, and it is not a conferment to the court of District Council. It is a conferment upon the officer appointed by the District Council. Now it is well within, according to my understanding, well within the spirit of that subpara 1 of the 6th schedule. Now 165 or so, similar notification. Well, 166 or so, but
Just a second. (166)
166 also, my lord, a similar notification, and I would travel again to 164. That's in 2006 conferment. And thereafter, my lord, may come to 2011 conferment.
167 is same?
Same, my lord. (169) also same. The judge, my lord. It's the car assembly, my lord. And 172, my lord. It's also confirming to Mr. Impa Martin.
170?
172, my lord. It's confirming to the officer, not to the court.
Now what is that 170?
Officer of the District Council. East Khasi. It is a confirmation 37 and 50. Here, Governor did not refer to Sapara 1 or Para 5. And this is, according to me, my lord, with due respect, it is a right conferment by the Governor under 37 and 50 Act. Till here, my lord, according to me, Governor conferment was right. Now, the problem appears to be started from 171. Here 171, my lord, session power was conferred to the ATC. Therefore, I was saying from the beginning, ATC was already there under 37 rules, my lord. And now, admittedly, 2011, when the separation of judiciary from executive was done, this confinement was given to the district and session judge. Though session division was not extended there. This has dropped last minute. And once separation is done, my lord, the ATC is ultimately, my lord, they are the judicial officer. They are the judicial officer. So by humble respectful submission is that governor was not ought to use the district and session judge, but since CRPC was not there at that point of time.
But prior to that, there existed a West Khasi Hills district.
One district was there.
West Khasi Hills district was there.
Yes.
With Nongstoin as its district headquarters.
Yes. Your Lordship is
How long has that been there?
My lord, the district, I think that existed for quite some time, my lord. But much prior to 2014. It was very much there. And the ATC was all along.
Prior to 1972, what was the practice?
Prior to 72, my lord, the ATC, my lord, ATC under 37 rules, they handle the cases, session cases also. Session cases also. And that session, the ATC, handle the cases involving one party is a non-tribal, one is a tribal. Or when both the parties are tribal, but it is the, my lord, district council officer who tried the cases for these two parties coming from the same district council. But that is the position, so far as I understand this properly, according to me.
Your problem with the 20th or 29th May notification, 2014, 171, is that it names the district and sessions judge. And on that date, according to you, there was no district and sessions judge.
Immediately, my lord. That is undisputed by the respondent also.
So, what was he?
My lord.
What was he known as? There was a judicial officer.
My lord.
What duties did he discharge?
My lord, before this 2014 separation, the executive, my lord, so-called MCS officer, performing the duty of a judicial duty under 37 rules. But the moment separation comes into being, my lord, these executive magistrates, so-called the MCS officer, are not allowed to handle. At that point, my lord, governor ought to appoint a judicial officer, or already judicial officer, to act as an ATC under 37 rules. And that ATC will try cases involving one is a tribal or one is a non-tribal.
So look at what he does.
Right.
The governor of Meghalaya is pleased to separate judiciary from executive in West Khasi Hills district, Nongstoin, and to appoint the district and sessions judge Nongstoin as the additional deputy commissioner. West Khasi for the, so as the additional deputy commissioner is all right, because that is 37.
Right.
But there is no district and sessions judge. So on whom is it being conferred?
This is conferred to the so-called the judicial officer appointed transfer as a district session judge, but has to perform as the ATC. Now, according to me, my humble respect submission is, if CRPC applied that time, 2014, this notification has nothing wrong, my lord. Governor can appoint session.
But CRPC did not apply, so there was no one designated as district and sessions judge.
My lord.
But there must have been a district judge.
My lord, there is no one. No one. Only the executive magistrate was there at the time of separation. At the moment the separation comes, my lord, the so-called MCS power has been taken away, judicial officer comes into play, and governor can appoint any judicial officer as the ATC, since CRPC was not applied. At the 173 also, page 173, with regard to Nongpo, this is conferred to P. Mauri, my lord.
Mauri is there, so Mauri has the authority.
Mauri as a, my lord, to act as a ATC.
Only Mauri.
Mauri.
Any other who came in place of Mauri didn't have authority, only Mauri would have authority.
Since it's a person designated.
Over here, this is in Nongstrand or Ripoy.
Ripoy, my lord, which we are concerned with, 2015.
And your case was not taken up by Mauri?
No, not another officer came. Another officer came.
And there was no further conferment?
No, 176.
My lord, no further conferment I come across, my lord.
Only Mauri was conferred, no further conferment?
My lord, I do not come across those additional conferment.
Yes.
Well, it says appoint Sri P. Mauri in charge district session judge Ripoy. Well, they say Ripoy. The office of district session judge Ripoy was created by this notification. Well, though CRPC was not applied. Therefore, my lord, since CRPC is not extended by issuing this notification, my lord, governor cannot create the office of a district session judge. Now, therefore, according to me, governor could have appointed her as a ATC to try session cases to those parties. One is a tribal, one is non-tribal, those exception area. But he cannot, or she cannot, my lord, she cannot try cases when both the parties are both the tribals. The district council has seized the matter, district council officer.
Come again?
My lord.
Is pleased to appoint
Mauri. In charge, district and session judge Ripoy.
Forget that.
My lord.
As ATC for
Ripoy.
trial of all offences punishable with death, imprisonment, life.
Yes. For a term of not less than 5 years under the Indian Penal Code or under any other law for the time being applicable to district. And also to...
Where is the previous notification pertaining to Ripoy?
Pertaining to Ripoy, prior to this, my lord, there is no conferment given to with regard to Ripoy district.
Was Ripoy a district before that?
Yes, it was very much one of the revenue district. 2015. Independent district, long ago.
So we are not concerned with anything. As far as this matter is concerned, Mauri is the first conferment. There is no previous conferment.
But
if there is no previous conferment...
Respected submission, this designation is a personal designator.
Sorry?
Since the conferment is in person, the moment Mauri is transferred, my lord, nobody can...
After Mauri is transferred, nobody has authority.
Nobody has authority. Including the session.
One
The session is not there.
176, notification is by the post this time.
That comes later.
That comes later.
That is 2018.
Oh, this page is torn off from here. See how you keep it. Give me the stapler, please. Staple the last page properly on the sides.
Yes, panel 176. This conferment is in office. AG is right, but the institution.
When was the trial in this case?
The trial started from, my lord, 2014 onwards and delivered the judgment in 2019. 2019.
So Mauri and Mauri's successor did it?
My lord.
Yes.
My lord. and 2018 conferment, page 176. Madam, session judge, madam. Session judge took over and conduct the trial and pronounce the judgment. And admittedly, madam, there was no session. That is the issue. Right. Now, when we read this language properly, my lord, with due respect, the session judge is not only allowed to try these offences, but they are allowed to hear the civil and criminal revision petition, my lord. Now, under subpara 1 of para 5 of 6th schedule, there is no question of appeal or revision. Session become the first original jurisdiction with regard to under para 5.1. Para 5.1. Therefore, Governor used the revision appeal, my lord. This is with the spirit of 37, my lord. 37 notification. So with due respect, Governor has wrongly quoted para 5.1. He was not supposed to quote this because he has already conferred to the officer of district council. Therefore, by this issue, my lord, he has created the concurrent jurisdiction. If lordship, we accept the argument of learned AG. Concurrent jurisdiction would be there. It depends on the parties.
But the last slide is this supersedes.
Madam, this supersedes, madam. This supersedes the Maori conferment. Now, it is no longer a personal designator.
Even Maori has said, even Maori when she was given,
yes, there was
this supersedes.
My lord, it says supersedes. Supersedes. But
so therefore, other district council goes.
But, therefore, my lord, that supersedes, even Maori also, there was no appointment of session that time. Perhaps that was a conferment to a certain executive.
May have been, but it's superseded.
Supersede, my lord, it is stated. I agree with that. Perhaps it was a conferment to some officer.
Very good. Yes.
Now, therefore, the, my lord, 2017 conferment, my lord, that page 175, my lord, which, my lord, even the government has placed before the Honorable Apex Court. 175, my lord, conferment. Even 175, just meet. Lordship may take the pain to peruse this 175.
We'll have to continue again unless you want to come back after lunch. Give me the stapler also. Oh, I have one. You should have stitched this, such a big volume with one staple pin. On the pages at the end all open up.
Yes, sir, that's a problem. I also, my.
175, 176. Just make a copy and give it to him because his page is missing. That's the last page copy. Yes, Mr. Chung.
My lord, only 175, my lord. This is the latest confinement to this officer of district council. Lordship kindly see. Just within 1 year, differences. Therefore, the intention of the governor, my lord, he was not
175.
175. Once I may start from the second paragraph.
This is Shillong.
Madam, Shillong. District Council. Now, further, the Governor of Meghalaya, in exercise of powers conferred by Subpara 1 or Para 5 of the 6th schedule to the Constitution of India, is also pleased to confer on Srimati Sisha Palari Letma as Additional Judge of the Additional District Council Court, Shillong, with the powers for trial of offences punishable with death, transportation for life, or imprisonment for a term of no less than 5 years under the Indian Penal Code or under any law for the time being applicable to the Khasir's Autonomous District Council. It says in that district, and she is one of the officers of the district council appointed by the governor.
Yes, but this is Shillong.
But Shillong, my lord. But this, my lord, the seat of the district council is in Shillong, but the jurisdiction is expanded to the entire territory of the council. Therefore, my humble submission is governor is still intended to confer power upon the officer of district council. He never intended to withdraw. If he withdraw the earlier conferment and given to the my lord session judge other, that is another case. Whether division is available, that is another issue. But governor is still well within the para 5(1), still conferring power upon the officer of the district council. In that view of the matter, 2018 conferment is limited to my lord ADC to try the cases. Both the parties are tribal, one is non-tribal. But he cannot take the cases of both the parties are tribal. Then that confusion starts, concurrent jurisdiction apply. My lord, party will, it depends on the choice of the party.
Concurrent jurisdiction does not apply. The Khasi Hill Autonomous District Council is for all the Khasi districts. But in respect of Riboy, he's carved out an exception from this and conferred it on the district judge.
My lord, that is true. I bow down with that, my lord. I bow down with that. And the power that...
You can't bow down both sides.
No, my lord. I agree, my lord. That 37 rule is the source for the...
Send shortcut, call for shortcut. Yes.
37 rule is the only source for the session. 2018 conferment. But once governor has conferred about the Lightma, officer of district council, my lord, the jurisdiction of that officer is expanded to all the territory, including the district council. Now, governor has applied his mind, my lord, judiciously and conferred with her, my lord. Therefore, once governor has conferred, my lord, he has already exercised the special power available in para 1, para 1, para 5. He cannot re-exercise it until he withdraw.
That's why he says in supersession.
The governor in 2018 conferment is a supersession to the Maori conferment, 2015.
Very good.
Not to the district council conferment.
Yes, Mr.
Some judgments, my lord, with regard to de facto, likely the AG take those plea. My lord, I have gone through the Bihari case and King Emperor case also. My lord, that case also reflected by the Supreme Court in 1981 judgment. Justice Reddy, Justice A.P. Sen, Justice P. Islam. Complete deal with this issue, de facto doctrine, my lord, doctrine. And by humble understanding of those judgments, along with the King Emperor case.
When do you want to do it? After lunch, or when do you want to do it? Some other time, some other day.
As your lordship.
As lordship.
Convenience.
No, you tell us.
I'm ready to tell us.
10 minutes only. I may take 10 minutes only.
You have 10 minutes, we'll understand.
Lordship, any time, lordship, subject to lordship
convenience. Any day.
I don't know how long AG will take again.
It's not much now. Issue is crystallized.
Yes, issue is very... Let's finish it off tomorrow.
Yes.
Yes.
Are there many matters tomorrow? There shouldn't be. There are? Tomorrow is Friday, is it not?
Yes.
Okay.
Yes.
Okay.
Comfortable, brother? Very good. Don't worry. Don't worry.
Problem.